What are you going over, Glenn?
What's that?
What are you going over?
What am I doing?
What are you going over?
Oh, well, a lot of the same stuff I have been going over. I try and stay out of commerce as much as possible. Somebody said about somebody having a revocable living trust. I don't think it's revocable. There's court cases that talk about it. It's that people have tried to revoke it, and the Supreme Court said you can't do that. So, but it can be dissolved and liquidated. Anyways, so what I was going to talk about is law. I try and stay away from, in the cause of necessities for taking up arms. It says the king has extended the courts of admiralty and vice admiralty far beyond their ancient limits to supersede the course of common law and publish and use and exercise the law martial. So you can argue one or the other. You have to be careful about mixing them. You cannot mix them. And when you start arguing commerce, you're basically dealing with a bunch of thieves. And so you have to be aware that, what's that maxim of law? Caveat emptor, buyer beware. And so that's why I just don't like to go there. I know how to nullify my signature if I need to. And I think that's one of the reasons they don't want to talk to me. Because I just, when they give me something to sign, I just print without prejudice there. And I sign bonds and plea bargains and all sorts of stuff by doing that. And then plus I tell them that Will Livingston, that ratified the Constitution, is my fourth great uncle. So that puts me in the position of being posterity. And so that means is that for them to even suggest that I'm involved in some contract is treason. And they don't want to go there either. So anyways, is somebody going to do the Bivens thing here, or do you want me just to go ahead, or what? I have no preference one way or the other. I can just go ahead if you want.
I think that Queen usually likes it to be done like 3 times, but I'm surprised she's not here. I see Lee is here, and she normally introduces you, but
yeah, well, that's what I was thinking. And although I think I am Your Majesty, she's there. I don't know if that's Queen or someone impersonating the Queen.
No, it's not.
Oh, it's an impersonator, eh? Okay, no problem. Yeah, I sent Lori a text. Maybe she's busy doing something. Who knows?
There is a recording of the Bivens that I made, but I'm not sure if it'll do. I'll have to get to my laptop to play it. I was wondering if this is something that you set in place, Glenn, or is this something that Queen wants?
I think Queen has been doing it. I think it's probably a good idea. It's the old story, an ounce of prevention is worth a pound of cure, right?
All right. I'm going to get on the laptop here. Give me a second. How was your New Year's, Glenn?
It was good. I went to bed early. this is Texas, and Texas is like a police state, and so there's cops everywhere, and I just soon not have those kind of interactions. You know what I mean? And I don't drink anyways. I don't drink. I don't smoke. I don't do alcohol. I just stay away from all that stuff because I don't like to lose control. And so, you know, I just figured, well, you know, I think I'll just go to bed. I was kind of tired anyways, and I did a few things on my computer till, 11 or so, and I just went to bed. And then I woke up the next morning, and it was the next year.
I forgave you. I told you already. Yeah, similar type of thing here. It was like, oh, okay, I'll lie down and just take a little nap and awake. And no, that never works out good. It's like to just be saying my good nights early, Yeah, hearing you last night was quite a shock to hear you in Daniel's room, but it was good to hear you because we missed last week. So, yeah, continue on with more of that or anything else you're inclined to talk about. Go for it.
Yeah, sure. I can't remember what I talked about in Daniel's room. I was, he gave me about 45 minutes, and so I wasn't able to cover all the material I wanted to cover anyways. And so I've known Daniel for a long time. And go ahead and do the Bivens.
Okay, I'll put it right over.
Bearing false witness, misrepresentation.
Wait, are you going to read it, please?
No, please play it electronically because I got a chart plug in.
This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Please raise your hand, say your name, state, and position.
You have to read it 3 times.
This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Please raise your hand, say your name, state, and position.
And number 3.
This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at today's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, or township agencies present? This is also for a notary, poll worker, school board member, anyone who signed an oath to the de facto government. Please raise your hand, say your name, state, and position.
Thank you, Wild Horse.
Okay, well, is this being recorded now?
Yep. Directive controls are all in place now.
Okay, well, I just filed a Second Amendment demand for relief in my federal case here in Texas. And so I think the justification for it, oh, that's not it. No. Right, this is the motion. So the judge has actually been kind of babysitting me. Under their rules are way more technical than they need to be. And I think he knows it. And so I'm not a lawyer, so I'm not required to follow their rules. And I kind of ignore them most of the time. But sometimes he makes me follow them. And so I don't object. I just go ahead and do what he wants me to do. I appreciate him babysitting me. So anyways, this is a motion to file a Second Amendment demand for relief. And so the argument is there's an emerging dictatorship. So you want to know how they get to be a dictatorship. They consider it to be you agreed to it. Anyways, there's an emerging dictatorship by these Roman cult bar members who assault you with the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. And this is a National Mutual Insurance Company. Is that pretty? Maybe I'll make it bigger so you can read it.
At the bottom right.
No, I was making it bigger in Word. There you go.
That works.
That's easier to see, right?
Nice. Yep.
I could probably make it a little bit bigger.
You can use the slider in the bottom right hand of your screen.
Oh, that's true. I'm used to using the keys. I just use control on my mouse. But you're right. You're right. I'll let you have that one. Okay, so anyways, there's an emerging dictatorship by these Roman cult bar members who assault you with the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. This is a National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company. Congress has exclusive legislative jurisdiction over Washington District of Columbia, and through their plenary power nationally, plenary powers dictatorship, by the way, covers those citizens even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. It's the U.S. Supreme Court, 1948. Plenary jurisdiction is a dictatorship. Courts full and absolute power over subject matter and the parties. Plenary is full, complete, entire. Complete power over a particular area with no limitations. And so that's dictatorship. And call it a contract with the objective of denying common law. So that's how they call it a contract. And then they don't have to, and in that plenary dictatorship, there's no common law. And this is, there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Under Texas law, no act or omissions of crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. And refuse to do anything about it when objected to, as described in the brief attached. The second amended demand for relief adds the Board of Disciplinary Appeals because all the bar grievances against 94 separate bar members, some more than once, that were dismissed as an inquiry were appealed to the Board of Disciplinary Appeals, which dismissed every case again. The Board of Disciplinary Appeals are bar members appointed by the Supreme Court, which is Hecht. So he's already being sued, okay, and the bar is already being sued. But I wanted to add the Board of Disciplinary Appeals. The defendant filed bar grievance against bar members with Purdue, Brandon Fielder, Collins, and Mott, which were all dismissed by the bar and the BOTA. The second amended demand for relief adds the State Commission on Judicial Conduct because the defendant filed dozens of judicial complaints, all dismissed, and 25 were dismissed on the same day. The State Commission on Judicial Conduct consists of 6 judges appointed by the Supreme Court, Hecht, and 2 attorneys appointed by the bar, subject to regulation by Hecht, and 5 members of the public appointed by the governor, a bar member. But no matter what, the bar members, there's more bar members than there's non-bar members, and it's easy to find a bunch of brain-dead idiots to go sit on there and do what they want, what the bar members tell them anyways. The second amended demand for relief adds the Attorney General of Texas, a bar member, because he's dereliction of duty to we the people. And this is a Kentucky court case. It is true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state. But under the democratic form of government now prevailing, the people are king. So the Attorney General's duties are to that sovereign rather than to the machinery of government. So his duty is to we the people. Because the Attorney General is defending these wrongdoers even when they're being sued in their private capacity, and he's facilitating these tax thieves by turning a blind eye to their activities. The second amended demand for relief adds the Texas House of Representatives Committee on the Judiciary, all bar members, because they're part of the problem. The second amended demand for relief adds a table of contents and evidence attached is incorporated into the text as a total of 17 exhibits. And I can go through that a little bit to show you what I'm talking about. And we'll get there, you know.
Yeah, I need to see that. That's where I think you left it last time, is with the exhibit. So definitely show us how you put that all in.
Okay. Well, this is maybe I'll do the PDF of this because it might be. I don't know. I like the Word file. It doesn't. Anyways, demand it requires. Okay, requirement. Okay, I don't beg. Okay, a lot of these bar members is prayer, you know, please, 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 sir, can I have some more? Well, I require it because I'm the king. Demand requires this court to grant defendant's motion to file a second amended demand for relief. Respectfully submitted, I'm not being disrespectful. Sign and seal a rank on the land under penalty of perjury. And they want phone numbers and email addresses. And so I put that stuff on there, but I'll tell you right now, that's the reason I don't answer unknown phone calls, and I don't have voicemail set up because I got tired of listening to telephone solicitors. So if someone sees that and decides they want to call me, it's not going to get answered, I hate to tell you, unless you send me a text first and I decide I want to hear what you have to say. Anyways, for what that's worth. Oh, and the judge wanted me to do a conference. So they all opposed it. but that's okay. The judge actually said, because what I did is the first amended demand for relief, he said I had to do a conference. And so I went and sent him a certificate and it said that there's been no conference. And he struck it. And then he said that I need to say who opposed it and if any, and who didn't oppose it. So anyway, so this is my certificate of conference. I talked to David Tabor, who opposed the Second Amendment demand for relief. I didn't even have to tell him what it said. Okay, he just automatically opposed it. And then Tammy Parker, she's with the U.S. Attorney. She didn't even answer. She didn't even respond. So I told them, if they don't respond, then I'm going to put it down as they oppose it. Jonathan Elzey, I told him, I left a message with someone there. It was a lady that took the message, said she would get it to him. And I said that if you don't respond, then it's opposed. Scott Graydon. Now, he was interesting because he's an assistant Texas Attorney General. He's really nice. I had a nice little chat with him. He says, so what's this all about? What's the Second Amendment demand for relief? What do you want to add in there? And I said, there's an emerging dictatorship in Texas, and they assault you with the Commerce Clause. And when you object to it, they refuse to do anything about it. I told them about the 94 bar grievances, against 94 bar members, some of them more than once, and they were all dismissed as an inquiry. And then the State Commission on Judicial Conduct. I told him all about that stuff. And he said, we would oppose the Second Amendment demand for relief. And of course he would. But he was very nice. And I said, well, thank you very much. And I hope you have a nice New Year. It was before New Year when I talked to him. And he says, you do the same. So he was very nice. But anyways, so that was interesting.
You would never get in touch with the Canadian politician during the holidays. You would have to run into them on a ski hill or, at an airport or something like that. You would never be able to get them on the phone. So, well done. That's astonishing that you did get in touch with somebody over that time period.
Well, I got a hold of Amanda Cates too, and that was yesterday. I called her up in the morning. And she didn't even ask what it was about or anything. See, the Second Amendment demand for relief, I think, they might have access to it online, electronically. I'll bet they do. The court said that it was to be stricken, but I'll bet you they still had access to it to see what it said. And so, and actually, the one that I actually filed with all the stuff today is actually different. Because I figured, well, if they're going to strike that one, that means it's not filed. That gives me an opportunity to make some changes. So I made some changes. Anyways, so Amanda Cates was Assistant Disciplinary Counsel of the State Bar of Texas, and I spoke to her, and she opposed it. And she didn't even want to know what was in it. Christopher Lindsay is another Assistant Attorney General. I think that just talking to Scott Graydon, who was Assistant Attorney General, I think just because of the fact that I talked to him, I think that's good enough. But I put down that I left a message for him, and he didn't respond. And so that's what that's all about. And then there's a certificate of service, 7 people I served these things on. I sent those all out today. And so that's the motion for the Second Amendment demand for relief. And then there's the brief. Yeah, that's the brief there. Okay. So, let's make it bigger. That way you guys can see it, and then people that watch the video can see it. Yeah, good. So, brief and supportive motion for leave to file Second Amendment demand for relief. Comes now demandants requiring leave to file Second Amendment demand for relief. Common law requirement. The Constitution of the United States, dated September 17, 1787, which is still in effect, has never been declared void, is the oldest written Constitution still in effect today. wherein Article 1, Section 1 states all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. In Section 8, Clause 9, that's Article 1, actually, Section 8, Clause 9, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution had not, prior to the statement in the Constitution being written, since this is Article 1, provided for a legislative Supreme Court. They were and could not, without any doubt, be referring to our one Supreme Court in and of the common law, which is already established and active in America and the United States of America. It's clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts. See, think about it. So Congress consists all legislative powers granted shall be vested in the Congress, which shall consist of a Senate and House of Representatives. So all legislative powers. And then Article 1, Section 8 says to constitute tribunals inferior to the Supreme Court. Well, they had to be talking about legislative courts because it's legislative powers. Anyways, so our one Supreme Court, Article 1 of the Constitution, then there set up legislative courts inferior to the common law courts as verified by the Seventh Amendment, Article 7 of the Articles of Amendment. Okay, so it's not really the Seventh Amendment. That's a slang, and it's really Article 7 of the Articles of Amendments to the Constitution, where it guarantees in suits of common law, no fact tried by a jury shall otherwise be reexamined in any court of the United States than according to the rules of the common law. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia, which is established by an act to establish the judicial courts of the United States, approved September 24, 1789. And that's the act that creates the Supreme Court and all the district courts and all of that stuff. And the Code of Law for the District of Columbia, 31 Stat 1189, March 3rd, 1901, establishes the Supreme Court of the District of Columbia, which is also known as the Supreme Court of the United States. And some of the judges, maybe all, are on both. It's kind of confusing, actually. And the nature of the jurisdiction is determined by the issues being presented. But the only true Article 3 court is our one Supreme Court, a common law court of the people, by the people, and for the people, and was in existence prior to the Constitution. And this is a U.S. Supreme Court case. Of course, that's the legislative inferior Supreme Court. Anyways, his rights as such are such as existed by the law of the land, long antecedent to the organization of the state, and can be taken from him by due process of law. Can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. That's U.S. Supreme Court 1906, Hale versus Henkel. So, law of the land is an interchangeable phrase with common law. Law of the land and common law both mean the same thing. So, again, they're referring to the common law was antecedent to the organization of the state. That's before the organization of the state. Long before the organization of the state. This sets the courts of common law separate and apart from legislative courts such as this court or the 97th District Court, otherwise being a maritime court in which when any case tried in this court or the 97th District can be reexamined by action of appeal. This places this court in the 97th District Court of one of the inferior courts referred to in Article 1, Section 8 of the Constitution of the United States. Note the difference from trial by jury in common law as to a trial with a jury in the legislative inferior courts. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law with trial with a jury. Common law trial by jury means the jury conducts the trial. It is self-executing and needs no legislative implementation to regulate its process or confer jurisdiction. And this is also important because there's a lot of stuff in the Constitution that needs legislation to be implemented or to confer jurisdiction, like a bankruptcy court, for example, right? there you got to go volunteer in. You got to declare bankruptcy. So there's a lot of stuff that is, and so this is important to say. This statement right here is important. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, which have never been altered by common consent in any way or manner, and presently remains in force, the last words of the introduction or preamble to the Articles of Ordinances, Section 14, state, the following articles shall be considered articles of compact between the original states and the people and states in said territory, and shall ever remain unalterable. Was intended to be part of the Articles of Confederation and forever unalterable, and all previous engagements entered into, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. That's Article 6, Clause 1. Includes the Northwest Ordinance, which is still in full force and effect in Texas. So the interesting thing about the Northwest Ordinance you have to understand is if you go to the Office of Law Revision Council, they say the 4 founding documents of the United States of America are the Declaration of Independence, the Articles of Confederation, the Northwest Ordinance, and the Constitution. So there's 4 founding documents, and the Northwest Ordinance is one of those founding documents. And the reason is that the king, in the definitive Treaty of Peace of 1783, granted a huge tract of land to the federal government. It wasn't in any of the states. It was, and I think they tried to sabotage the U.S. by doing that, and maybe did to some extent, but it's hard to say. I think Congress kind of neutered it when they went and passed this Northwest Ordinance. Anyways, it was basically, they agreed that the United States had sovereignty over all the territories south of the Great Lakes to the Mississippi River Valley, west to the Mississippi River Valley, and from the Great Lakes down to the Ohio River Valley. And so that's a huge tract of land. There's probably about 8 states in that territory now. And so what it does is it defines the nature of federal jurisdiction in federal territory. And so, you know, if you think about it, if you understand how the law works, the federal territory is like everywhere, and there's 2 jurisdictions everywhere. You can be in the federal territory or you can be in the state. You can be in the District of Columbia or you can be in Texas, for example. And what they do is it's like an overlay. And what they do is they assault you with zip codes and do all this little tricks that they like to play to assault you with the federal territory. And if you're in Texas, then they have nothing to say to you. Anyway, so that's what's happening, which is in full force and effect in Texas. The compact agreement is a federal injunction and forever unalterable either by legislative Congress or its legislative Supreme Court or its other inferior courts or the administration. It is protected by Article 4, Section 2, Clause 1 for this Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. And so, citizens of each state, so that's talking about 2 classes of citizens there. Okay, you have to understand that. Citizens of each state and citizens in the several states. Article 2 of the Compact Agreement states the inhabitants of said territory shall always be entitled to writ of habeas corpus and trial by jury and of judicial proceedings according to the course of the common law. And so it really neuters the federal government. It really does. And they really just don't have any power over anything. Except if you're in the District of Columbia, and there they have it's a dictatorship. Legislative law, statutory law, is in fact an extension of maritime law. The 1946 Administrative Procedures Act, Title 5, United States Code, Section 559, that's Sentence 2, requires the administrative law to be in conformity with the Constitution for the United States of America, and the common law, with all its prohibitions, restrictions, restraints, and limitations imposed by its enumerated bounds and boundaries as described in the first 10 amendments. History is clear that the first 10 amendments to the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government. And the Maritime Code, otherwise known as statutory law, being administered in legislative inferior courts, this court and the 97th District Court, as evidenced by maritime gold braid flag or the corporate seal in the courtroom, also acknowledges that when brought inland beyond the high water mark or the first bridge of any navigable river, they must be brought in compliance with and in conformity to this Constitution for the United States of America and subject to the common law. And this is the original Judiciary Act of 1789. Well, part of it. Saving to suitors in all cases the right to a common law remedy where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizance of all seizures on land or other waters than as aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States, which is the government incorporated, and that's 1 Stat 77. That's the original Judiciary Act. So the right to a common law remedy where the common law is competent to give it. And then in the judicial code that they passed like in the 30s, third, of all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. And so that's taken from the judicial code of, I think it was in the 30s when Congress passed that. Thus meaning competent, common law. So they're explaining why common law is competent. Common law is not extending in the reverse of the high water mark. It's not going out to the sea. It's only on the land. And extending to sea or the jurisdiction of maritime law or to exercise jurisdiction as stated in Article 1, Section 8, Clause 17. So there's no common law in the District of Columbia where it declares that the inferior tribunals will exercise exclusive legislation as prescribed by Congress over such district not exceeding 10 miles square. So that's where the seat of government is, and it's a dictatorship there. But common law is everywhere else. And what they do is they're expanding, they're using the Commerce Clause, which is only effective really in the District of Columbia. The boundaries of the District of Columbia expand as necessary under the Commerce Clause if you're involved in commerce. But commerce is not any contract. Commerce has to do with the fake money, with the banksters, with all that stuff. International law. Commerce, my right to have a simple common law contract, my right as a man to engage in a contract with my neighbor to do something for him and he gives me some gold or silver or even fake money. Doesn't matter. That's not commerce. And you have to understand that. And the courts have talked about that. And so anyways, over such district not exceeding 10 miles as may by cession of particular states and the acceptance of Congress become the seat of government of the United States and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So the military. Okay, you got to understand, if you're in the military, there's no common law in the military. But they do have rules they follow. Anyways, to make all laws which shall be necessary and proper for carrying into executing the foregoing powers and all powers vested by this Constitution of the Government of the United States or any department or officer thereof. So that's Clause 17 and 18 of Section 8. Therefore, all legislative courts have jurisdiction in the District of Columbia only under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial paper, Federal Reserve notes, forced loans, which are only for use in the District of Columbia at 12 U.S.C. Section 411, and the Gold Reserve Act of 1934, 48 Stat 344. Legislative statutory inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss, which states every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. Equity is talked about in the Bible. It is the rule. It was the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. And so this is Strauss versus Strauss. Obviously, that's a divorce case. Whereas we learned that the law of the land means the common law, State versus Simmons. Remember, I told you the common law and the law of the land, it's the same phrase, means the same thing. Justice O'Neill speaking for the court, Taylor versus Porter, at 4 Hill 140, 1843, Webster's definition of the law of the land at Dartmouth 4, Wheaton 518, at 581 and 82, which is affirmed by Article 4, Clause 2, which declares this Constitution. No, that's Article 6, Clause 2, sorry, which declares that this Constitution shall be the supreme law of the land. In Wiley versus Collins, 1851, acknowledges the common law and the Holy Bible from which it came, which is the foundation of the common law of our God-given constitutionally secured rights. And why that's so important is if our rights come from God, then only God can take them away, not some government. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution, Public Law 97-280 at 96-1211. See, I know after having grown up in communist Canada, the communists up there like to, they want to get rid of any references to God in the Constitution because, again, it goes back to if God's not involved, then your rights and everything are up for grabs. That's the communists like to do. They want to enslave everybody, and that's what's going on right now with this dictatorship that's emerging. Anyways, this legislative inferior court fails to be an Article 3 court. The United States District Court is not a true United States court established under Constitution Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belonging to the United States. So you think about it, even the federal court here in Texas is here to regulate federal territory. This court is required to provide the demandant and federal property. Okay, so make all needful rules and regulations respecting the territory or other property belonging to the United States. Okay, that regulations are by definition property, but there's other property too. We the people aren't the property, the government's our property. And so the government there's a trust. Because of the oath of office, there's a trust created. And there's court cases that talk about it. This court is required to provide the demandant a Republican form of government, Article 4, Section 4, Constitution for the United States of America as one of we the people. The demandant is a state in this union because we the people are the state and have immunity against these County of Montague corporate thieves under Article 11 and Amendment and their bar member handlers. The government's but an agency of the state being the sovereign people. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. So we, the people, are the state. That's Chisholm versus Georgia, 1793. A Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. These County of Montague corporate mafia and their bar member handlers engaged in the theft of the defendant's land with their forced rendition, and the bar members are the most culpable. And that's who really I want to go after, because they should have known better. You know, a lot of these people that work for these, like the tax assessor, I mean, that's just, you know, she's an idiot. And but the bar members are the ones that are behind this thing. Anyways, the individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. So they can't steal my property. He owes nothing to the public so long as he does not trespass upon their rights. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 77(9)A and 36 Stat 1611, Section 256, Part 3. And it's an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder and prohibited, because they are inferior legislative courts, which are an extension of the legislature, and there is no Article 3 judge present. Therefore, it's a non-judicial proceeding act targeted at property owners. No separation of powers. In 1861, the Southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on the 15th of April, 1861, at 12 Stat 1258, Lincoln ordered Congress to reconvene under executive authority. And 3 months later, on August 5th, 1861, at 12 Stat 292, while operating under executive authority, Congress approved an act to provide increased revenue from imports and pay interest on the public debt and for other purposes, which is the act that precipitated all of this. And Congress has been operating under executive authority ever since. In 1871, under executive authority, Congress created a municipal corporation called United States for a government for the District of Columbia, 16 Stat 419 under Roman law. And now there are two national governments, one which Congress operates outside and independently of the Constitution for U.S. citizens and resident aliens under the Commerce Clause, Article 1, Section 8, Clause 3. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. It's Downs versus Bidwell, U.S. Supreme Court. The legislative inferior Supreme Court ruled on a case that Lincoln failed to like, and Lincoln sent troops to the legislative inferior Supreme Court, which resulted in Rule 45, process mandates. All process of this court issues in the name of the President of the United States. Therefore, there is no separation of powers, and everything is under authority of Congress, operating under executive authority, and this legislative inferior court is actually the executive branch, operating under Roman law, and all officers of this legislative inferior court are executive branch administrators with no common law. And there's no common law offenses against the United States, only those acts which Congress has forbidden for disobedience of its command or crimes. The state of Texas is a municipal corporation operating under executive authority, which is a subsidiary of the United States Corporation domiciled in the District of Columbia, operating under the Commerce Clause executive authority with no common law. Under Texas law, no act omissions a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Congress passed the Code of Law for the District of Columbia at 31 Stat 1189, March 3rd, 1901, which is now known as United States Code, which all courts, federal and state, operate under. Posterity. This legislative inferior court is operating under the demandant's authority because Will Livingston, who ratified this Constitution for the United States of America on behalf of New Jersey, 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity as found in the preamble, and the demandant's entitled to right of blood. And no civil law can destroy right of blood because all the laws of Congress and all the laws of Texas are civil laws. Right of blood and kindred cannot be destroyed by any civil law, and this court is operating under power which is derived from the demandant as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. Let's just pause this for a minute. Somebody just tried to call me, so I got to mute here, and I got to find out what's going on.
Okay, sounds good. Well, I'll hold the fort. Well, that must be somebody that he knew that called, because I've called Glenn from an unfamiliar number before back in the summer. I got a reply of, "Who is this?" So he definitely doesn't answer unfamiliar numbers. I know that.
Nick, could you send me a link in Glenn Fern's, any document in Glenn Fern's subdivision of your domain? Well, I have to call these things.
Okay, well, they're not answering, so I guess we'll just continue on.
Sounds good.
The power which is derived cannot be greater than that one from which it is derived. Therefore, it's impossible for the demandant to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And John Marshall, the chief judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for the demandant to confer a sovereignty which will extend over him. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers were not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. That's why they have to get you into the Commerce Clause. I'm telling you, and even that's if you claim to be posterity, they can't even get you into the Commerce Clause. You know, that's like treason. Okay, think about it. They're trying to get the king into a contract by which the king gets enslaved. That's like treason. Anyways, and the demandant is exempt from these county of Montag thieves or their bar member handlers, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And that just like nails it. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to make to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, which is the supreme law of the land. Anything or constitution or laws of any state to the contrary, Article 6, Clause 2. Bar equals Vatican, which is this 1871 corporation is owned and operated by the Vatican. It appears that the bar changed in 1947 because of the Bar Treaty of 1947, which is supposed to be effective in the District of Columbia only. Somebody's kind of making some noise there. I think I'll mute them. There we go. BAR is an acronym which stands for British Accredited Regency. Okay? Some people say it's registry, and that's not true. It's Regency. Because all bar members are appointed under the authority of the Inns of Court. Inns of Court, these are certain private, unincorporated associations in the nature of collegiate houses located in London invested with the exclusive privilege of calling men to the bar, which is one of 4 law schools located in the city of London, which is owned and operated by the Vatican from the concessions to the Pope, 1213. And so we will establish a perpetual obligation and concession that from the proper and special revenues of our special aforesaid kingdoms for all the service and customs which we ought to render for them, saving in all things a penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael, 500 marks, and at Easter, 500 marks, 700 namely for the Kingdom of England, and 300 for the Kingdom of Ireland. And the concessions to the Pope precipitated the Magna Carta, because King John was trying to correct revenue to pay to the Vatican, as evidenced by Chapter 29, which put a stop to their non-judicial proceedings. No freeman shall be taken or imprisoned or seized or outlawed or any way exiled or otherwise destroyed. Now shall we go upon him or send upon him, but by the lawful judgment of his peers or by the law of the land. So think about it. That's putting a stop to their non-judicial proceedings. This is nothing new. And several chapters of the Magna Carta where they were prohibited from charging certain fees. And all bar members are here as regents. That's why it's called British Accredited Regency. A regency is the office or jurisdiction of a regent or body of regents. A regent is a person who exercises a ruling power in a kingdom during a minority absent or of the disability of the sovereign. We, the people, are asleep at the wheel. Because the District of Columbia Municipal Corporation, set up in 1871, called United States, went bankrupt in 1933. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. And that's United States Congressional Record, March 17, 1993. Do you think it's changed? You know, it's hard to say. I think something happened when we got attacked in 2020. I think that I've heard some rumors. Anyways, that's not the topic of what we're going to talk about today. We can talk about it after if you want. And is owned and operated by the Vatican. This is Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. As evidenced by the Roman Achaea military staff carried in battle by all Roman commands and planted on all conquered nations, sitting on the right side of the speaker's podium in the United States House of Representatives. I've seen recent pictures of that, and that staff is gone. And the 2 Roman fascias on the wall of each side of the speaker's podium. I didn't notice about the fascias. Anyways, but that staff was gone, and I'm not sure if it's like, I don't know. Got to look into it some more. Therefore, all bar members are foreign agents of the Roman cult, here to impose martial law rule for the Vatican. There's 3 kinds of martial law. There's full martial law. You have a declaration of martial law is issued. Troops are put on the streets, used only during wartime, used on a foreign country when actually invaded by a foreign power to put down an armed rebellion. Martial law proper is the law of the armed forces. When a captain tells a private what to do, it's enforced by court-martial. Remember this federal enclaves, okay? So that's martial law proper. So in D.C., it's martial law proper. Martial law rule, the law of necessity and emergency, allows the domestic use of martial law powers used during times of peace. Ex parte Milligan, and that's ex parte Milligan is where this is taken from. In the District of Columbia only. Okay, so this martial law rule is supposed to be in the District of Columbia only under the Commerce Clause, which continues to this day. And this is U.S. Senate Report number 93-549. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought in force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. And I don't think it's changed, although I think there's some things in place that it's starting to change. So we'll see. And anyone who hires an attorney is an imbecile. Clients are also called wards of the court. That's Book 7 of Corpus Juris Secundum, Section 4, attorneys. A ward of the court is an infant or person of unsound mind. Wards of their rights must be guarded jealously, which is why the bought and paid for clerk buyers selling her just as in the 97th District Court was operating her star chamber with her forced bar member buddy because she intended to presume jurisdiction. In propria persona, in one's own proper person. It's a rule in pleading that pleas to the jurisdiction of the court must be pled in propria persona because if pleaded by attorney, they admit the jurisdiction. As an attorney is an officer of the court, he's presumed to plead after having obtained leave, which admits the jurisdiction. And the demandant's ancestors attempted to prohibit these foreign agents of the Vatican from holding any office of trust. Requires an oath of office as found by this original Article 13 an amendment taken from 1819 Virginia statutes. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain any present pension, office, emolument of any kind, whatever, from any emperor, king, prince, or foreign power,
You cut out there.
What's that?
You cut out there.
I know I had a cough. So, anyways, such person shall cease to be a citizen of the United States incapable of holding any office of trust that requires an oath of office or profit under them, salary, or either of them. Under them is the federal government, either of them is the state government. And that's the original Article 13 and amendment. But it seems to have disappeared around the Civil War period. You know, I think it was because Lincoln couldn't hold office because he was a bar member. But any rate, and that's as taken from the 1819 Virginia statutes. And it has come out that the Vatican was involved in recent election interference. That has come out. Quasi-contracts. The Texas codes are all bills of pains and penalties. The Texas Penal Code, because they assault you, penal as in penalties, right? Texas Penal Code, because they assault you with a quasi-contract using their District of Columbia Municipal Corporation and Roman law. Assumpsit. I've even seen people that go into court and they'll say, what do you plead, guilty or not guilty? And they'll say, I plead non-assumpsit. In other words, I don't agree to your contract. And the case disappears. Anyways, assumpsit, in its origin an action of tort, was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based and forced upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account. See, these are all commercial terms. Okay, you got to understand that. With case upon a bailment, a warranty, and bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of the fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. Which requires a minor estate. U.S. citizen or other fiction, constructive quasi-contracts are based solely upon the legal fiction or fiction of law, so they can assault you with a quasi-contract for their penal action. The words penal and penalty, in their strict primary sense, denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, on the other to actions for private injuries into which parties aggrieved may by statute recover punitive damages. If you nail them down, you got to ask them and nail them down. They'll actually come out and say it's quasi-criminal. It's quasi-contract. A penal action is one. What's that?
Sorry, the word quasi is new too, right? That's all been implicated just recently because quasi is a legal term. That's, that kind of screws with people's head because what is quasi?
Yeah, I know. Fake. A penal action is one founded entirely on statute, brought with the sole object of recovering a penalty or forfeiture, imposed as punishment for a specific offense, while a remedial action is one brought to obtain compensation or indemnity. Which is why they use the Roman law of capitis diminutio. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. The highest and most comprehensive loss of status. When this occurred, when a man's condition was changed from that of one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and family rights. Because capitis diminutio is used when they enslave you, and they are Satanists using fraud and deception to sell you into slavery as collateral for their minor estate. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, the fake judge is actually a bought and paid for clerk masquerading as a judge. It's the accepted rule, not only in state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, or otherwise act as mere clerks of the involved agency. which is why it's a bill of pains and penalties and unconstitutional, because they have no authority to do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. But the reality is the bar members do it all the time. The prisons in Texas are populated by quasi-contracts, and the bar members did it in this case. The War of Independence was fought over taxation without representation, and now these District of Columbia bar members using the Commerce Clause to bring the District of Columbia outside a maximum of 10 miles square. And that's, again, that National Mutual Insurance Company versus Tidewater Transfer Company, in violation of Article 1, Section 8, Clause 17, to represent the demandant by force and make false legal determinations for the demandant, that the demandant's a minor estate, that the demandant's an imbecile, that the demandant's a taxpayer, the demandant's their slave. So then they can tax the demandant. And this is Longborough versus Blake, U.S., 1820, U.S. Supreme Court. If it were true that according to the spirit of our Constitution, the taxation must be limited by the right of representation, whence is derived the right to lay and collect duties, imposts, excises within this district. If the principles of liberty in our Constitution forbid the raising of revenue from those who are not represented, do not these principles forbid the raising of it by duties, imposts, and excises, as well as by direct tax? In other words, they have to represent you. And use it as justification for the theft of the demandant's land. The demandant requires this court to grant the demandant's motion to file a second amended demand for relief. And that's it. And then there's an order I went and provided. So I had to keep that under 10 pages. So it was getting close. It was getting close. Yeah, it was getting close. So I had to keep it under 10 pages. Otherwise, you got all sorts of requirements and crap that you have to do. Anyways, that's what I was going to say.
And then what about the exhibits, too? You said you were going to...
Oh, yeah. Okay.
Show us that.
Yeah. Okay.
And then there's the fact that they're not landowners. They're not to be landowners. Like, I'm not seeing enough case law out there that, that's showing us that government is not to be the landowners. It's the people that are the landowners.
Well, again, we the people are the state, but we the people are asleep at the wheel, and we the people need to start stepping up, and that's why I say we need to form our common law juries, with this case is a good example. I'm kind of curious to see what the judge does with it, because I'm telling them, well, I'll show you what I'm telling them, what the relief I'm demanding. It's in my it's in the second amended demand for relief. This is what the second, and so then I got this table of contents I added in, as you can see here. And then there's the exhibits. Okay, so there's actually 17 exhibits. And this is all part of the table of contents. And so then in the preamble, this action is brought as a collateral attack on a void judgment made by the bought and paid for clerk masquerading as a judge, Patricia Coleman Byers, with her Star Chamber, in conspiracy with bar members named herein and their County of Montague Mafia handlers named herein. And this is a few court cases. There's actually quite a few court cases on void judgments. A void judgment is one which, from its inception, was a complete nullity and without legal effect. A void judgment, insofar as it purports to be a pronouncement of a court, is an absolute nullity. A void order may be attacked either directly or collaterally at any time. A void judgment is one which, from its inception, is and forever continues to be absolutely null and without legal efficacy and effectual to bind the parties or to support a right of no legal force and effect whatever, incapable of enforcement in any manner to any degree. So there's actually a lot of cases. There's Canadian cases, too, that talk about that. Okay, so engaging in the theft of the demandant's land. And this is U.S. Supreme Court, this is a recent 2021 court case. Chief Justice Roberts, opinion of the court, the founders recognize that the protection of private property is indispensable to the promotion of individual freedom. As John S. Adams tersely put it, property must be secured or liberty cannot exist. Discourses on Davia in 6 works of John Adams, 280. This court agrees, having noted that the protection of property rights is necessary to preserve freedom and empowers persons to shape and to plan their own destiny in a world where governments are always eager to do so for them. People do not expect their property, real or personal, to be actually occupied or taken away. The Constitution, we explained, is concerned with means as well as ends. Anyways, and then I talk about the jurisdiction, and this is the federal question. Like there's several statutes or codes under there. It's the code of law. They call it United States Code, but it's actually the code of law for the District of Columbia. And so remember I said at the beginning, it said that Congress walked out, ceased to have a quorum. On the 15th of April, Lincoln ordered them to reconvene, and in August 5th, 1861, they passed this law for property taxes. And there was actually another one for sales taxes passed in 1862. Anyways, so there's one in 1861, 12 Stat 292, providing for tax assessors and collector at Section 9, 12 Stat 296, required to execute a bond at Section 10 at 12 Stat 296. They have an oath of office, Section 11, 12 Stat 297. The Secretary of the Treasury to provide regulations, 12 Stat 297. A direct tax on lands and lots of ground, Section 13, 12 Stat 297. A Board of Assessors at 12 Stat 300. Tax liens, Section 33, 12 Stat 303. So it's all right there in that act. So this is a federal question. Anyways, so I've kind of gone through this before, so I don't think we want to go through it again. I'm telling them they're involved in a bunch of felonies, and I told them in that notice and demand, and then this legislative inferior court and the corporate mafia, common law. See, all of these are what happens is in Word. Word is actually pretty useful, and I did this when I wrote my book, because you can actually use Word to, create a table of contents and an index and a table of authorities and all sorts of stuff. And it's all automatic if you know how to do it. It's real simple. And Word is really useful for that. Anyways, so what I did is periodically, let me just do a search. Right. This is talking about at Exhibit 17. So, common law, Article 3 Court of Competent Jurisdiction, or one Supreme Court, issued an affidavit of finding of facts, which is attached here too, which this inferior legislative court is required to recognize. It is self-executing and needs no legislative implementation to regulate its process or confer jurisdiction. And it's at Exhibit 17. Okay, so that's where I incorporated into the text. So all of them have, so here's Exhibit 14. This is the rendition of taxable property, and that's Exhibit 14. And then there's the stuff from Jonathan Elsie. Exhibit 16 is the 25 dismissed judicial complaints.
All in one day.
All in one day, yep. And
you need to write a book about all of this trends unfolding. After it's run its course, you need to definitely write a book about that.
Well, I could probably take some of these court documents and manipulate them and turn them into a book pretty easily. Anyways, land ownership in America. Anyway, so Exhibit 1 is the grant deed and bill of exchange. I should have, in hindsight, I should have called it a bill of conveyance. That was a mistake. But at the time, I was doing the best I could, and so, you know, that's all you can do. I mean, there's defects in it. There's no doubt about it. But a lot of it depends on the corruption of the local officials. And so so then I went and served them when they started sending me their threat letters through the mail. Okay, when these County of Montague Mafia started sending their threats through the mail to the minor estate of the theft of the demandant's land, I served them with this notice of demand by registered mail. And that's got them. I'm telling you, that's like, I think that's big problem for them. I served by registered mail. Registered mail, it says at 12 Stat 705 that is prima facie evidence of delivery. So, you know, they haven't disputed that they didn't get it, so they got it. They'd have to make an affidavit saying they didn't get it. Registered mail, you know, I don't think they can weasel out of that. Registered mail is kept under lock and key by the post office. There's a whole bunch of stuff that the post office does for security measures with registered mail. So, you know, I don't think they can weasel out of that one. Anyways, so I got my exhibits. So then let's just go down to, so this is all part of the second amended demand for relief. Yeah, and what happened is in 1876, you know what happened? Think about it. We had the Civil War going on. So in 1861, they went and passed this act by Congress. But meanwhile, the Civil War is going on. Texas is just barely getting occupied. And so the war's it's got to go on. And I think it goes on to like, what, 1863 or 1864, maybe even 1865. And so then it took the Texas legislature till 1876 to pass an act, because if you read that act, it's by apportionment. So what they do is they assign each state a certain percentage of the revenue that they need to collect to for this tax. So it's by apportionment. And so then the states have to pass an act for it too. And so this is the act that the state of Texas passed. And it says that Section 1, be it enacted by the legislature of the state of Texas that all real and personal property in the state, and then it says the property of corporations, new, existing, or may hereafter be created, and property of all banks and banking companies now existing or may have to be created, and of all bankers, except such as hereafter expressly exempted, is subject to taxation. So it's corporate tax. It's a corporate tax. And then it goes on in Section 4. It says the term person, whenever used in this act or in any other act relating to the assessment and collection of taxes, shall be construed to include firm, company, and corporation. And the word include is limiting. And there's court cases that talk about it. Include is to confine within, to hold as an enclosure, to take in, attain, shut up, contain, enclose, comprehend, or embrace. It's like a nut includes the seed, okay? Which means that in the statute that says the term person, whenever used in this act or any other act of regulating the assessment or a collection of taxes, shall be construed to include firm, company, or corporation, it means it's only a firm, company, or corporation. And further evidencing their intent to assault the demandant with their minor estate. When Hager authorized the chief appraiser to require rendition that's not mandated by the tax code, as found in instructions for the Form 50-141. I think I got that guy in. He's going to be gone. I'll get him disbarred. Under the top of the first page, near the top of the first page, it's at Exhibit 14. So they got a problem here. I'm telling you, they definitely have a problem. I'm going to break it off in their ass. Anyways, talk about the bar here. So a lot of that stuff's already in there. Quasi-contracts, bill of pains and penalties, capitis diminutio, Texas tax code, rendition, the minor estate. It's created by the Vatican. It's all satanic and deceptive. Don't get me going. So this actually was less pages than the one that I did before, because I took some stuff out that was, anyways, I took some stuff out and then added in a bunch of stuff. Fake judges. Let's do the summary. These Bowie Independent School District Mafia wrongdoers and their Montague County Appraisal District Mafia wrongdoers, accomplices, and their bar member Mafia wrongdoer accomplices, and their bought and paid for Legislative Inferior 97th District Court Mafia wrongdoer accomplices are nothing but a District of Columbia extortion gang who think they can hide behind their District of Columbia corporations and pillage anything they want, getting rich off the backs of ordinary people with their forced rendering scam, and they're extorting fake money and stealing their land for failure to pay the extortion. And the State Commission on Judicial Conduct and the State Bar of Texas are their accomplices and encouraging it under the supervision of Ken Paxton and Nathan Hecht. Buyers, the bought and paid for a clerk, masquerading as a judge, is required to be under the supervision of an Article 3 judge, and the defendant has serious doubts if there are any Article 3 judges, since they're all foreign agents of the Vatican. And even the Legislative Inferior Supreme Court of the United States convenes the Vatican's conclave when they have a meeting. But in any event, the Article 3 Justices Court of the Common Law Affidavit of Finding of Facts and Judgment GWF 24003 is the only court of competent jurisdiction in this matter, and this Legislative Inferior Court is required to recognize it. Governments are but trustees acting under derived authority and have no power to delegate what's not delegated to them. But the people, as the original fountain, might take away what they have delegated and trust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. Nor does the conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both. Sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. John Locke declared tyranny as the exercise of power beyond right. Tyranny is the exercise of power beyond right, which nobody can have a right to, but for his own private, and this is making the use of power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law, but his will, the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think that this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that's put in any hands for the government of the people and the preservation of their properties, it is applied to other ends. It is made use of to impoverish, harass, subdue them to the arbitrary and irregular commands of those who have it. There it presently becomes tyranny, whether those that use it are one or many. And Patrick Henry coined the phrase, "give me liberty or give me death," after witnessing a man flogged to death for refusing to take a license, and a license a contract. They wanted him engaged in a contract. They wanted to do a commerce. A license is a contract. The license is express or implied. And this is that Longborough or license tax cases. The requirement for paces of such licenses is only a mode of imposing taxes on the licensed business. And the prohibition and penalties against carrying on the business without license is only a mode of enforcing the payment of such taxes. So it's about a business, first of all. the recognition by the acts of Congress of the power and right of the states to tax, control, and regulate any business
I guess Glenn got a call, everyone. We're just standing by.
I'm hearing a lot of real estate, property, business can only be taxed, blah, blah, blah. Getting back to the property, they surrender all their rights when they become a public official.
Okay, I'm back. A friend of mine had a stroke, and nothing I can do about it right now. Maybe we'll go see him well, they're saying that he's not responsive either. So, hopefully, I don't know. I guess we'll see.
That's not the news we want to get. Sorry to hear that. I hope that he recovers quickly.
Well, yeah, really. But, my attitude, there's a story in my family about one of my ancestors that died when he was 99 years old, and he got kicked in the head when he was shoeing a horse. And, I always say I want to go on an airplane crash because it'll be quick. You know what I mean? But something like that, 99 years old, he was healthy enough that he was out shoeing a horse, and he got kicked in the head. It was quick. Can't be a better way to go. You know what I mean? So, I don't wish any lingering illness on anybody. I see these people that wind up in these nursing homes for months and even years, and, I wouldn't wish that on anybody.
No, that was one of the questions in nursing school was which percentage of the citizenship ends up in these these facilities, right? Yeah. And of course, everybody answered wrong because it's such a low number that it's actually, it's a gift to actually, become old, right? Because life is one kick in the head after another. My mother experienced getting a hammer not put over her head. So, there's one kick in the head after another. So, becoming old is actually a gift. But it's surprisingly only 6% of us end up in those facilities.
Well, that's good.
Yeah.
I'm not a very trusting sort, so I don't like these pharmaceutical drug pushers. I don't think that they're interested in doing anything for you. But the bottom line is I don't want to see anybody suffer. And if they go quick, then at least it was quick, and they didn't, none of this lingering illnesses thing, you don't wish that on anybody. If you got to go, nobody's going to get out of this life alive. And so anyways, yeah, so a friend of mine had a stroke. That's what I just got informed. And, hopefully, well, they're saying he's non-responsive right now too. So I guess we'll see. So anyways, let's keep going here.
Yeah, a friend of mine just before Christmas, well, a friend of a friend, actually, I should say, young old woman, okay, so in her early 60s, just, everybody saw her that one day, and then the next day, she was found in her unit, okay, with her clenching her chest, and was found dead. So she, it surprised everyone because, she was walking around not complaining about anything. And then the next day, everybody's getting, told to, what do you want of your friends because she's no longer here, sort of thing, right? So it was quite a shock to hear. Well, we're hearing terms now called dying suddenly and turbo cancer. Like, we didn't hear those terms 10 years ago, right? So
Right.
there's an agenda out there.
There definitely is. There was actually, I've heard stories of doctors back in the 30s. Like, there was a story about a doctor that was in medical school back in the 30s, and somebody had cancer, and they went and called all the students in and said, here, this is someone that has cancer. You'll probably never see it again. And then I've heard stories of how doctors have said that I've never seen anybody that wasn't vaccinated that had cancer, or that had cancer that wasn't vaccinated. That was it. And so it's these damn vaccines. They're trying to kill people off. And so anyways,
One moment. I just want to address that heart attack thing. Evidently, you can feel it coming on. Now, I seen the lady, I don't know why. But what you want to do, I heard this from Doc Wallach. I'm all into natural medicine. Now, I thought that when it would happen, you'd be able to count of 3, No. It's very quick. In through your nose, out through your mouth. In through your nose, out through your mouth. You'll feel it when it's coming to stress and time to exhale. Very important, because this will release your your veins going into your heart and your arteries. I call them arteries. Your arteries. Yeah, and it'll relax and expand them, and do so. Try to do it with a yawn type throat. The more oxygen, the better. And
You know what I heard?
Doing a yawn, for real.
Regarding
it comes on, you can feel it. Fast, in through your nose, out through your mouth.
My friend apparently just the day before was complaining of chest pain. So, yeah, there was indications. Yeah. So let's let Glenn continue on with his case. But yeah, we're hearing it more and more and more. Too much, Mary. You're right. Thanks for giving us those things that we can watch out for. We're never well informed enough about those things. So continue on, Glenn, please.
Well, and for alternative remedies, Hawthorn. Hawthorn is for your circulatory system, and it's real good for your heart and all your circulatory system. My sister-in-law has a story about the snowbird. The snowbirds were in Phoenix, and there was a snowbird down there. That's a guy from Canada that's in Phoenix for the winter, right? And he had chest pains. He went to see this cardiac surgeon. The cardiac surgeon says, well, you got some blockages here. You need a triple bypass. And the guy said, well, I'm from Canada. I'll just go back to Canada and get it done for nothing. And the next year, the same doctor was looking at the same snowbird and the snow. And he says, you know, last year you were here and you needed a triple bypass and now you don't. And you didn't have it done because there's no scars. And so what did you do? And he says, oh, I went to see this herbalist. Anyways, so then the doctor, the cardiac surgeon, needs a triple bypass. And he goes to see my sister-in-law, doesn't tell her anything about it. She does a live blood analysis. She'll show you blood under the microscope and then tell you what the problem is. And she says, well, you got some blockages here. You need to take these herbs and come back and see me in 6 weeks. And so he does and comes back to see her in 6 weeks. And she checks him over. She says, okay, you're fine. You can go now. He doesn't believe it, goes and checks himself, gets a friend to check him. 3 months later, he walks out of surgery. He calls her up. He had just walked out of surgery. He couldn't cut into somebody knowing it wasn't going to do him any good. And he had this crisis. And so anyways, she said that he decided to quit the medical profession and go back to school and become an herbalist. I don't know if that's what happened, but, you know, she's got some amazing stories like that, I'm telling you. Anyways. What's that?
Yeah, Hawthorne is worth mentioning again because it will regulate the heartbeat. If you've got a low heart rate, it will bring it up, and if it's high, it will bring it down. Where no medications, nothing synthetic out there can do that. And Hawthorne grows naturally everywhere on the land. So just
you probably got a hawthorn tree in your backyard.
Yeah.
Anyways, yeah, and it's a food herb too. I asked my sister-in-law about that. Can you take too much? Some herbs you have to be careful with. And it's a food herb, and you can't take too much. It doesn't hurt you if you take too much. Your body just uses what it needs and discards the rest. Oh, and another one is cinnamon. Cinnamon. There's some pharmaceuticals that are made from, and I can't remember what they are. But anyways, yeah, cinnamon's another really good one. Anyways, let's keep going with this. What I do is these bar members named herein are communists, liars, thieves, and murderers, and tend to demand and follow up on the traditions of his ancestors and arm up and hunt them down and blow their brains out so they can have an excuse to murder the demandant and shed some innocent blood for their Roman cult god Baal. Or in the alternative, if they fail to kill the demandant, sell the demandant into slavery with a quasi-contract in the Texas kangaroo courts under hex supervision, because either way their thieving bankster buddies get to pillage the fake money in the minor estate treasury direct account. Excuse me. Under the Hague Convention concerning the international administration of the estates of deceased persons. Excuse me.
Bless you again.
I can use all those I can get. Anyways, concluded 2nd October 1973, and they'll get to collect a commission from the minor estate account with the Treasury, and if the demandant does turn up dead, this is his deathbed testimony. Anyways, so relief required. The demandant requires a declaratory judgment. So what I did is I filed this lawsuit, and I'm essentially asking the judge to dismiss it. If you think about it, the demandant requires a declaratory judgment recognizing this. Damn.
Bless you.
Recognizing this case as res judicata because of the common law court affidavit of fact and judgment, the only Article 3 court of competent jurisdiction in this matter, and further recognizing buyer's void judgment is vacated, and that demandant's land returned and their extortion refunded immediately, and these mafia investigated for extortion on other people. The demandant requires a declaratory judgment that the vexatious litigant codes in Texas are unconstitutional, and it's none of the business of Deborah Spisak or Tom Lowe or Stephen Lund or Keith Ogle or the bar members in the Texas House of Representatives Committee on the Judiciary or anyone else as to whether the demandant pays any filing fee, tax, extortion. The demandant requires the bond of Deborah Spisak, not a penny more, not a penny less. The demandant requires the bond of every member of the board of directors for the Montague County Appraisal District and the chief appraiser and the county attorney, not a penny more, not a penny less. The demandant requires the bond of Nathan Hecht as an accomplice to these bar members named herein, not a penny more, not a penny less. The demandant requires the bond of Glenn Heeger, so I'm wanting their bond. And I put in there not a penny more, not a penny less, because that's coin, okay? And so I'm not asking for any commercial paper. So it's basically I'm looking for bonds. The banner requires the bonds of all bar members named herein, not a penny more, not a penny less, and their bar card revoked, because all bar members are deemed to know the law. Therefore, it was deliberate, calculated, and malicious. The demandant requires the state part of Texas put into involuntary bankruptcy, dissolved and liquidated, and all their bar members be investigated for populating the prisons with their quasi-contracts selling people into slavery. The demandant requires that laymen be appointed to the judiciary and the state bar of Texas be completely disenfranchised in Texas. The demandant requires all the Texas codes about unlicensed practice of law be repealed. The demandant requires $1 billion in lawful money pursuant to the Coinage Act of 1792, 1 troy-ounce silver eagle coins with a face value of $1 each, or as a less desirable alternative, its equivalent in fake money, as required by the common law court affidavit of finding of facts and judgment GWF 24-003. And the credit bureaus Dun & Bradstreet on Wall Street be ordered to list it in their database as a lien against their corporate mafia with all consequences until it is paid in full. A true copy of which is attached here too, all of which is incorporated herein by reference in its entirety. The demandant requires the minor estate be dissolved and liquidated yesterday. Not today, yesterday. And the demandant does not care what they do with the fake money in the Treasury Direct account. They can shove it up their rectal orifice. Anyways. And then there's the exhibits. So then these are the exhibits.
Would you consider the clause, if they go silent clause, it's called acquiescence clause. So is that your acquiescence clause that you're putting in there, that you are entitled to a default judgment? Like, because you are entitled to apparently full restoration if there's been any discrepancy done by any attorney. So they have no just cause in this case, or in any foreclosure case, really, right? So your entitlement is up to, the Bible states, up to 7 times the value of those bonds. So you're just...
Yep, I agree. We'll see. I don't know. Quite frankly, what I expect to happen is at some point there's all these motions to dismiss. There's and at some point the judge is going to rule on those. And I did a motion to. Matter of fact, I've got a couple I have to respond here, probably in the next few days. But I expect, in the past, when I filed lawsuit, there's been times when the judges had dismissed it so fast, didn't even have a chance to effect service. Okay? And in this lawsuit, the judges actually told me, he counted the days out, and he said, I have to have service done by the 2nd of January. And so now that I've filed a second amended demand for relief, that'll start the clock ticking again. I'll have another 90 days or 120 days, actually. And so if he allows it to be filed, that's going to be the question. If he allows it to be filed, then I'll have another 120 days. So he'll probably issue an order. So what I expect is the judge will start coming out about those motions to dismiss, and he'll start basically granting them or denying them, one of the two. There's a possibility he might grant some of them, and other ones he might deny. And I think that there's an interest. Okay, I think that otherwise he would have dismissed it a long time ago. I mean, I filed this lawsuit in August, and so what will happen is at some point, some of the people are going to get dismissed off the case, and some of them won't be. And so then the ones that are dismissed off it or that aren't dismissed off it, what will happen is I'll have a chance to appeal the dismissals. Depends on, like, the state bar. I am fully prepared to take that to the Supreme Court. I don't have a problem with that. I think I got them, and they need to. No matter what, it's going to affect some change. There are going to be some big changes in the courts in Texas. They're not going to be selling so many people into slavery anymore. But I'm prepared to take the state bar to the Supreme Court, because they're nothing but a bunch of this and Hecht and those guys and all of those guys. I'm prepared to take that to the Supreme Court. I wouldn't be surprised if he dismissed them off the case, but I think I made a pretty good argument as to why they should be on it. And so, you just don't know. You don't know what's going to happen. Now, as far as the county of Montague, these bar members, I can guarantee you that if they go just get dismissed off it, they're going to be calling me up wanting to settle a matter. And so then right now, honestly, there's I could really use, $10 million. I don't know what the offer is going to be, but I could certainly use a settlement of some sort. And so I might, you never know, I might take them up on that and settle it as far as these Montague. But I really want these bar members. That's unacceptable. It shouldn't have come to this. These bar members, these bar members, I want some bar cards, I don't know. Who knows what I'll settle for? And that's what I'll tell them. I'll tell them, make me an offer. Who knows what I'll settle for? And they'll say, no, you guys, you didn't have to do this. You didn't have to do it. The bar members are really the ones that I hold at fault. But the county attorney, okay, his name was Clay Riddle. He could have put a stop to it. And he didn't. And because I sent him the registered letter, so I consider him to be just as culpable. So anyways, we'll see what happens. I have no idea what's going to happen. I think I got him by the short and curly, so I think I really do. The question is how long is it going to take to get a settlement? Because if it continues through the litigation, then we start going to discovery, and I start saying, where's the rendition form? I'm going to start, doing production of records, request to admit. There's going to be a bunch of stuff that we're going to do to move this thing forward. And but I think that they're going to want to settle it, and I think that's probably what will happen, depending on if they're, motivated. But these bar members, I'm prepared to take the state bar to the Supreme Court, quite frankly, because this is unacceptable. These bar members are really the ones that are at fault here. It should have never come to this. Anyways, so this is the exhibits. So there's Exhibit 2, final notice before suit. So you see here that fails to have a signature and name of the cowards. See, look at this. This is what they sent. Despite our previous notices to you, the taxes shown in this notice remain unpaid. I have recommended to my client that a lawsuit be filed against you. I don't know who it is. I don't know an address. I don't know anything. And then this is that minor estate. Okay, they're assaulting me with that minor estate. And so, it's a coward. They're just cowards. They think they can hide behind their corporation. And I'm gonna break it off in their fucking ass. I'm really I got them. This is the final notice delinquent tax suit, and they extorted $2,200 out of me. And so I think there's going to be a crash in the markets in April. So if they offered me a mill before April, or I had the mill before that crash, I might take it. You never know. Because I think I can really, someone that has, if you have a lot of money, you can really profit from something like that. You know what I mean? Anyways, so this is I filed a challenge to jurisdiction, and this is the challenge to jurisdiction I filed. And it's interesting to note that there was a couple things I filed with that document, but I attached that Catherine Phillips. Here's that Catherine Phillips notice and demand. It was attached to the challenge to jurisdiction. This is Catherine Phillips notice and demand that I sent it to. Let's go up to the front. That was a challenge, and what happened is they refused to get it from the post office. So I mean, I got them. I'm telling you, because there's just all sorts of shit that's going on in this case. I'm going to get some people fired over this for sure. I sent it to Catherine Phillips, Clay Riddle, the Montague County Attorney, Kim Jones, the Montague County Clerk, and the Montague County Treasurer. And so I'm telling them in here that you guys are involved in a bunch of felonies. And I go through the law and explain it to them. And tell them that perjury of oath. They're bringing the District of Columbia outside 10 Mile Square in violation of Article 1, Section 8, Clause 17. I'm entitled to a Republican form of government. They're violating my rights under the color of law. They're conspiring to threaten, coerce, injure, intimidate me in the free exercise of my rights. So I got a bunch of felonies that I'm accusing them of here. They're subjecting me to their satanic religious ceremony, 18 U.S.C. 247. Talking about that minor estate, official oppression, mailing threatening communications. It's not near the ones. I got a whole bunch more that I added, but right here at the end it says, you're hereby notice that this is a good faith attempt to get you to correct your records by taking my land off your tax rolls and your failure to provide a bona fide contract by which I have knowingly, willingly, intentionally agreed to your taxes, and any further communication attempting to collect the tax extortion or because of any non-payment of your taxes extortion shall be multiple felonies, including but not limited to all the crimes described herein, and this notice and demand shall be evidence of your intent to engage in all the crimes, including but not limited to those described herein, and it shall be further evidence that Clay Riddle, Kim Jones, Jennifer Finoglio, and others intend to be your accomplices and co-conspirators, as well as your agreement that I file criminal complaints against you and bar grievances in your private capacity and seek other remedies. And so I kind of nail it there, I think, this delinquent tax. And so I sent it by registered mail. This is the registered mail receipts. Jennifer Finoglio picked up her own. See right there? She signed for it. I don't know who this is. Maybe that's Catherine Phillips in using her other name or something. Jeanette Morrison, Clay Riddle, okay. So he didn't sign for it himself. Kim Jones signed for hers. So they can't say they didn't get it. And then I had this corporate denial affidavit. I'm not a corporation. And they're assaulting me with their corporate law. This is all part of that package that they refused to get from the mail. And I got my statement of original status. Talks about my ancestors, how Will Livingston is my fourth great uncle. It actually doesn't say that, but it's got pedigree charts right here. So right here. William Todd Livingston is my fifth great-grandfather, and his son was Henry Livingston, and his daughter was Mary Polly Livingston. And so it would make sense that William Todd Livingston had another son by the name of Will. Anyways, so I'm saying he's my fourth great uncle, Henry's brother, and puts me as posterity. I'm posterity anyways. They want to argue about it. Anyways.
Yeah, don't screw with your gene pool.
Yeah, well, prove I'm wrong. You know, when you make a statement, you got to have firsthand knowledge. Prove I'm wrong. I got that pedigree chart. I think it speaks volumes. So anyways, there's where I served it on the liar, and this is where the court refused it. Sent it to the court. They didn't pick it up. So anyways, don't get me going. You're going to get me going here. Demand to dismiss for failure to prove standing. So this is all the evidence that I did in that whole case, eh? So there's a challenge to standing. And then there's the Spisak letters. I filed a petition for a writ of mandamus to the Court of Appeals, and the clerk sent them back because I'm a vexatious litigant.
That's a fictitious term.
I guess. Anyways, so all of that stuff is here. These are all the attachments. What I did is, get a load of this. This is the demand to disqualify the judge. And this judge actually disappeared. 78 affidavits of criminal complaint were filed into this case on or about 27th day of February 2023 and 14th of March 2023. And here's the certificate of service. It was sent to the liar and the court at this other address. They have two addresses, so you don't know which one to use and not use. If they got two addresses, they should be picking their mail up at both addresses. Anyways, it's another certificate of service. And here's that judge's oath of office. He disappeared. And here is the where I sent it to the liar, and he disappeared. And then this is the other demand to disqualify the judge that I sent with that challenge to jurisdiction. And the court refused to pick it up as part of that package. This is their website showing box 167. That's the address I used. So I think they got a problem. Anyways, don't get me going. This is all the evidence. Oh, this is that rendition form. General property rendition of taxable property. And it says the chief appraiser may require rendition that's not mandated by the tax code. So the Texas comptroller right here, public accounts. So they're the ones that made this form. They're the ones that are responsible. They assaulted me with their liar Jonathan Elsey, and this is where they made me pay his fees. So it's a star chamber. And this is the 25 dismissals of judicial complaints. Notice the date, April 22nd, 2020. April 22nd, 2020. April 22nd, 2020. And what they do is they give it this number, and you don't know which judge that is, and there's 25 of them. How am I supposed to know which judge is which number? And so then they dismiss 25, and they attach the form. If you have new evidence, explain in the new evidence in this other form. How do I know? Even if I did, there's no way I'd be able to do it because I wouldn't know which one is for which judge. It's just a bunch of crap. Anyways, so, that's why I'm suing the State Commission on Judicial Conduct. It's just a scam is all it is. 25 of them, April 22nd, 2020. April 22nd, 2020. April 22nd, 2020. I went and see the numbers of 34, 32 because I had them attached. Sorry?
Well, that's during the scandemic, so they had lots of time to sit and contemplate stealing folks' land. Right?
Yeah, no shit. Yeah, no shit.
So, what is this zone that your land is in? What is their plans for this land? Is it it's not simply just to resell it for the taxation, is it?
Oh, probably. I got a storage unit on it. I got everything I own in that storage unit. And so I really I don't have the money to pay for a storage unit. I built a storage unit on it and put all my junk in there. And so I kind of need a place to put my junk until something happens and I get a job. I haven't worked in 10 years. Anyways, don't get me going. And then this is the affidavit of finding of facts from the Supreme Court, common law venue, original and exclusive jurisdiction. Right here. Anyways, and this is 29 pages. So, anyways, I guess that's about it. Does anybody have any questions?
Yes.
Okay.
Earlier you said, what was that phrase you used? Right to kinship, and was it bloodline?
Right of blood?
Yeah, the right of the kinship and I think blood, something. Yeah.
Yeah, I have right of blood. Yep. I could. It's a maxim of law. I have it in all of my stuff here. I'll search for it. There we go. Right there. The man is entitled to right of blood. No civil law can destroy right of blood. And this is the maxim of law. The right of blood and kindred cannot be destroyed by any civil law. And all the laws of Congress and all the laws of Texas are civil laws. So I have right of blood. Everybody has right of blood. Just depends on what your right of blood is. You see what I'm saying? My right of blood is the fact that Will Livingston ratified the Constitution for New Jersey. And Will Livingston was the first governor of New Jersey. And so that's right of blood. We the people. See what I'm saying?
Yep.
Well, you do a phenomenal amount of work, so I know that you're going to
I got lots of time. What's that?
No, you've done a phenomenal amount of work, so I know that the outcome is going to definitely pay off, and definitely get rid of these wrongdoers. I like the way you toned it down.
Yeah, I toned it down for sure. Yeah, from the other one. The judge seems to be babysitting me. He's definitely helping me. He tells me, like, when I filed that second amended demand for relief, he told me I had to do a conference, and so I sent him a certificate saying I didn't do any conference. So then he dismissed it and said, well, you're not supposed to do it that way. You have to do a conference where you find out who agreed and who disagreed. So anyways, they all disagreed. So I sent a conference and they all disagreed. We'll see what happens, But he's babysitting me. That's the way I look at it. He's babysitting me, and I appreciate it. And I'm certainly not going to give him a hard time about it. And I think he understands that. So, they have to, because I'm not a lawyer, they have to, accommodate people that aren't lawyers. And he's certainly doing a good job. I appreciate it.
Yeah, it sounds like he's actually trying to give justice here, because he knows that you're actually speaking to other folks regarding your situation, so he knows that you're a high-profile individual.
Well, I've been in this court. I probably have. I went and sent the judge. This guy his name is Hal R. Ray, and he's a magistrate judge. Okay, he's really not. He can't be an Article III judge. Okay, but the magistrate judge have to be under the supervision of what they consider to be an Article III judge, a real judge, and the real judge is Reed O'Connor. And I've sent Reed O'Connor. I've dealt with him before in other cases. I guarantee you they know who I am. I sent Reed O'Connor one of my nasty grams, and I've sent him to other judges there. I sent him to the clerk, and the clerk would send it back. I sent a nasty gram against a judge by the name of McBride, and the clerk sent it back with an unsigned letter, and it said, "You've got so many open cases here, we didn't know which case to put this on." And they said, just write the case number on the top, and if there's more than one case, make a copy and write the case number on the top, and we'll file it with that case. And so I said, okay, sure, no problem. The clerks are actually very helpful. But, it's right. I got a lot of cases there. I must have about, well, let me look. I can tell you, I got them all in my... in the Northern District of Texas, in the Fort Worth division, I go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 of them. This is the 10th. And then I've also got another 4 of them in the Dallas division. And so, yeah, they know who I am. And I've had other cases that would get dismissed so fast your head would spin. I mean, I didn't even have a chance to effect service. I think in a way, they do that as a favor because they don't want you to spend the money on affecting service and all this. But on this one, he actually sent me an order. You got to have service affected by the 2nd of January. And so that was great. I had lots of time. And, yeah, he's been helping me every time there's a motion to dismiss. He'll send me an order saying, I have before me this motion to dismiss, and you have until this time to respond to it. And, or you might have an order that you might not like, but that's all it says. And, it's to the point, and it's brief. It's a one-pager. And, so I appreciate it. I appreciate him telling me, and I get that stuff in there in time for sure. And, so anyways, that's why I say he's been babysitting me. So here, I'll show you. I'll share my.
Well, after all your babysitting that you did for everybody, you deserve a little bit, in my view.
I appreciate it. That's for sure. This is all the cases I have open or have in the Northern District of Texas right here. So there's 14. And some of them got dismissed really quick. Some of them, they said, the clerk said they're all open. I don't know. I don't know if they're open or not, but they were willing to file them into the case. Anyways, I thought that was kind of interesting. So I've sent, and the nastygram, I don't know how much you know about my nastygrams. It starts off, it says, normally I say I accept your oath of office, but you and I both know you have no intention of honoring your oath of office, so fuck your oath, you lying, perjuring motherfucking son of a bitch. And then second paragraph says, you or your pigs want a piece of me? Just name your date, time, and location. I'll come armed. We can settle it for once and for all, you lying, perjuring motherfucking son of a bitch. So that's one of my nastygrams. You see what I'm saying? And it's like 20 pages of that.
And then I thought, didn't you send, no, that was somebody else sent like 100 pages of blank pages or fully blacked out pages just to complicate or block up the fax machine. That's another way of doing nastygrams. I've heard that being done. So I'm glad you didn't take that route.
No. But I think they, if there's anything I learned is if you're on point, they respect it. And so, I, like with the nastygrams, I think that they respected that. And even like in my case, when I go through and explain the law, that they're not an Article 3 court and they don't have any authority. And the real court that has authority has already made a ruling. and they respect it. I got to tell you, the first time I did this, I filed a lawsuit in Texas, and it was against FedEx. FedEx removed it into federal court, and I didn't want it in federal court. I figured they were going to dismiss it anyways. So I told the judge, and this judge was Means. His name was Means, M-E-A-N-S. Anyways, I told him I have nothing but contempt for you and your so-called court. You have an inferior court of limited jurisdiction, and everything you do is brutum fulmen. Brutum fulmen is Latin for an empty noise, a judgment void upon its face and all that stuff, Anyways, I've never had a judge be so nice to me after that. I felt guilty. I mean, I really did. I felt guilty. I felt, like, oh man, I shouldn't have done that. Anyways, and he ultimately dismissed it for not doing the electronic filing. And when he did dismiss it, he brought up the fact that I said all his judgments are brutum fulmen. I think it's hilarious. Anyways,
I wonder how many of those came across his desk before.
I guarantee you, not too many. So, I really think that they respect it when you point out the law, and you're right, and so I'm telling you, you're not an Article 3 court, and you don't have any authority, and I just want you to dismiss it because it's res judicata to this other case, Anyway, so I think that they're sympathetic, and I think that that's why that judge was telling me, he said that I had to do the conference, okay, the certificate of conference. I think he wants me to start opening up a dialogue with these other liars, and so that they can make an offer to settle this matter. So I think that he knows that I'm right. I'm 100% right, and they are wrong, and they're going to lose. And so he's opening up the dialogue.
Smart. Then he's actually got some brain cells that are actually functioning. That's good to hear.
Yeah, so we'll see. That's all I can say. Anyways, I suppose we're about done. Does anybody else have any more questions? Can you send me the recording once you get it there, and so I can keep it in my collection?
I have a question, please. Could you please
What's that?
post this? Could you please post this in your room? I'd like to review that. That is great. There's so much.
What post what?
Your case, is that accessible to
The
us?
second amended demand for relief, or the motion to the brief, the motion to proceed.
That could be applied to so much, not only real estate, but you touch the maxims, you touch everything, case law, and you cite it so eloquently. And I'm nervous on how to style and format and be so bold as well.
All
I
of them
forget they're
are,
rats.
yeah, all of them are, Glenn has been very gracious with us and posted everything in his room. And then we're going to be posting this chat in the replays probably by tomorrow morning. So you can get all that insight. And also, Glenn is available for consultations. Like, he just doesn't work on his cases. He's got quite a few other cases that he's implementing with other folks. So if you need help with styling and formatting your case, then definitely get in touch with him, Mary, okay?
Yes.
If I have uploaded, let me look here. Some of these documents have already been uploaded to the group, to the room, like the second amended counterclaim was uploaded, although probably not the latest one. I've made changes to it. See, I've uploaded like a brief in support of a motion and then a response to a motion to dismiss. All of those, usually what I do is it's a motion to strike because you don't have standing. You're a government lawyer, but there's a motion for relief. There's a lot of stuff that I've already uploaded to the group. So if you have something in particular that you want me to upload, I don't mind doing that. This PDF that we're looking at is a pretty big file. I don't know how big that file is, but it's got like about 200 and how many pages? 264 pages. So it's going to be a pretty big file. Second amended counterclaim 01/02/25. So it's the latest one. It's the one that I just filed today. I just filed it today. And so, I don't mind filing that. These are all public documents. It's in the court records. So, it's not like it's private. If you tell me what you want me to upload, I can do that.
The question is, I heard some really cool guys saying, in fact, you should take out your checkbook and make me whole. And
well, it's going to come to that.
I want to know if one does that and demand property returned, would it be? Here, I think this is. I typed it up. This is a different thing. Could you still grab his bonds? That's what I need. I want to know how to shut them all down. I found out that not only the first judge who started this, that the next judge is not only in the bar association. We have in Chicago, they got gay bars. Oh, no. He's a part of the gay bar association, and it's just so disgusting. And he just put I requested his bond. This is new judge. He used to be in the other court where this old one who referred me to him, he used to judge over there. They're all associates, which is called a circuit now, and they're not even appointed. I'm sorry, they're not even elected. They're appointed by their cronies. And just today, this guy got his oath on record by the chief judge. It's still not worded correctly, and it's just ridiculous. So if I demand that he would take out his checkbook and just for fucking bothering me, they're just so
No, Mary,
boldly.
Mary, we can't keep
Could I
Glenn.
still sue them and take their bonds and all that in like a criminal, as well as convicting them?
First of all, I never asking the judge for his bond. You don't do it that way. What you do is you talk to the clerk and find out how to get the bond, how to get a copy of the bond. The clerk usually has that kind of information. It depends on your local jurisdiction as to where who keeps what. Like in Texas, the Secretary of State has all the oaths of office for all of the district judges. But if there's a county judge, then the county clerk keeps the oath of office, and then if there's a bond, it'll be in the same place. And but under this Dodd-Frank, back after 2008, they changed it so that most of these judges don't have bonds. A lot of them don't. It's basically insurance that's covered by the government, and so they don't have a bond. They're still got insurance, but what it is, and if it's defined, it's hard to say. But I never ever say that to the judge in front of them. You go around behind them, you go to the clerk, you tell them, I want their oath of office and surety bond. And I've had judges actually send me a copy of their oath of office and surety bond. And but that's pretty unusual. Usually you have to go and hunt around and try and get a copy of it. And in every state, it's going to be different as to where they're kept, and it depends on what kind of a judge they are. But I never ever say it to them. What I will do is I'll tell them I accept your oath of office. I'll send them a notice and demand. I accept your oath of office, and here's a copy of your oath of office, by the way, and remind them about the supreme law of the land and all the rest of it. But sometimes that doesn't do any good either. They're pretty flagrant sometimes. And so then there's a state commission on judicial conduct. And at the end of the day, sometimes you just have to sue them. And you got to know how to do that. But you don't talk about bringing out checkbooks until, any lawsuit, the first thing to do is they try and get it dismissed. They have immunity. They got all their arguments as to why they want to dismiss it. You get past that point, now you can talk about, usually they're calling you up and wanting to settle a matter. But they're going to try and get it dismissed. The liars are going to try and get it dismissed first of all. And so they filed, in my case, they filed a bunch of motions to dismiss. And I filed counter motions to deny and a motion to strike, because the lawyer is not a private attorney. This is a government lawyer, and he's not authorized to represent them because they're being sued in their private capacity. And so again, you got to justify all that, and you got to explain why. And so you don't talk about that stuff until the time is right. Otherwise, you don't say anything because it's a moot discussion. Anyways, that's how you have to do it. I don't talk about bonds in front of them. You have to be careful about mixing your law. And so I talk strictly law. And when the time comes, if I want I want their bond, and again, if I get their bond, then they're out of business. Okay. They can't do what they're doing anymore. They can't even, who knows, maybe they can go out and get a job digging ditches or something. But if I get their bond, they're done. And so I'm not asking, for anything beyond their bond. I just think that they need to go find a different line of work, that they'd be more happy and that they can, and not hurt people and that kind of stuff. But, that's all I'm asking for.
Not hurt the Republic.
Yeah,
More
well, and I'm
like
asking them.
them
I'm
bothering
asking
you
the. I'm
and
asking
trying
the
to
FBI to investigate for criminal activity, but I'm not saying they're guilty of criminal activity. I'm saying just investigate, and if there's something there, then do what you have to do. But again, I'm not an expert on that stuff. I know there's some evidence, but is it enough evidence? They're entitled to due process of law. Everybody's entitled to due process of law, and so is there enough evidence to that you can get a conviction? I don't know. And so, but there's certainly some evidence, just enough is the question. I think that I've got enough, but, I don't know. And I don't expect them just to take my word for it. I expect them to go out and investigate and find out and do their due diligence. That was one of the things that they responded to me, because I went and sued the FBI special agent in charge, and I said he's not investigating. And I said there's a website called let me find it here. It's called Targeted Justice, and that's it's got affidavits on there by what's his name? The guy, the FBI agent from he's dead now. He was in charge of the Los Angeles Olympics. I mean, some very prominent FBI agents say they actually do this, where they certain targeted individuals, they refuse to investigate felonies and they refuse to prosecute felonies against certain targeted individuals because they want to take reprisals against them. And so I think that's what's going on in my case. And so I'm not expecting them to do anything more than what they would do with anybody else. But I expect them to get off their ass and investigate this. Anyways.
Yeah.
All right.
Ted Gunderson is one of those.
Yeah, it was Ted Gunderson. Ted Gunderson. And there's affidavits. You go to targetedjustice.com, and they talk about how there's some lawsuits already, but there's lots of evidence that the FBI has been doing this for years, and they would just refuse to investigate felonies that they're engaged in or somebody's engaged in against certain targeted people, and the U.S. attorney refuses to prosecute them because they're people that are targeted. Anyways, don't get me going. So I'm telling them that I want, they need to investigate it, and they said
get off your orifices.
That's right. Yeah, they don't necessarily have to take my word. At least go and investigate, and if there's probable cause, if there's evidence, then do something about it. I said, I expect them to do their due diligence. I expect them to go and investigate, but do something instead of sitting on their ass.
Yeah, fair enough. No.
So anyways, well, I guess we're about done here. It's 11:30 here. So thanks everybody for participating, and thanks for the questions.
Hey, thank you for showing up, and it sounds like you're coming down with a cold, so I want you to go get a sauna or something and sweat that cold out of your system, so you're not feeling or you're up to fight these lefers, these wrongdoers.
Yeah, I'm taking vitamin C.
Pineapple juice is good too. It's got more vitamin C than orange juice, by the way. So,
that's good to know.
Get some of that. So yeah, thanks for all the updates on your case. It's been very, very enlightening, and I've looked forward to it all week because we kind of ended up missing last week, which was my fault, I know, and I won't be doing that again. But thank you so much for coming tonight, Glenn.
All right. Well, thanks for putting up with me, and I apologize. I missed last week, and so that's why I needed to get here for this one. But I'm just going to upload some of this stuff here. Second amended, I'll upload the latest one that I filed today.
Yeah,
And I'll
mentioning
upload the
surveillance stuff in your case is a guarantee. I'm told by not just one person, by a couple, that if you mention surveillance that they're doing to targeted individuals in your case, it's dropped instantly.
Well, I think the judge is sympathetic. I had actually a judge in Dallas that sent me an order of deficiency, and the order of deficiency said I need to file a lawsuit. So, I think that some of these, they read that stuff, and if they see something there, then they say, well, you need to file a lawsuit. So this is the brief. I'm looking for the second amended demand for relief, and I might not have changed that file name. Usually I change the file name. I might not have changed it. I changed it on the PDF side, but I bet you I didn't. And I might have uploaded already. So maybe I'll just upload it again. Yeah. Okay. So there's 3 files I'm uploading right now. And these are all ones that got filed today. They're the Word files. So you can download them and take the arguments and manipulate them. Oh, yeah, targeted justice. So, yeah, she went and uploaded this got this targeted justice website that she just put on there. Yeah, no shit, that's good stuff on there. And so you got good stuff, because I brought that up, and all of a sudden the U.S. attorney's gone completely silent. And so that means what happened is the U.S. attorney appeared and did a motion to dismiss and started calling me sovereign citizen and all that. Well, the Congress in 1940 said that we have a sovereign American sovereign citizen day, or actually, is it month? Maybe even, or maybe it's week. I don't know. But we want to put this day as a sovereign citizen day, and to impress upon our young people that the importance of citizenship. And they call them sovereign citizens. And so I brought up all that, and the Supreme Court in 1873 said everyone is sovereign, everyone not privileged. And so they're saying it's a bad thing. So it sounds like they're taking reprisals against me for my political beliefs, and they're engaged in war crimes. And my government can't commit treason, so they can't be representing the United States. They're operating in their private capacity, and so I think the court should strike that. And the court hasn't responded, but I wouldn't be surprised to get it struck. We'll see. I would be surprised, but I'll bet you the judge responds, and who knows what'll happen. But I think that they got a problem. I think they know they have a problem. Anyways, so I uploaded those documents. Thanks for everybody.
Thank you. Okay.
All right.
So, Happy New Year and all that jazz, and we'll talk to you next week. And I'll talk to you during the week too, because I want to find out whether or not you received my stuff from communists.
I will. I'm going to go check the mail tomorrow. So if I do, I'll let you know tomorrow. I don't go there all the time. I go there maybe a couple times a week at the most. Depends on how much stuff is coming in. And but so I'm going to go there tomorrow. I need to check the mail. I know there's stuff there waiting for me.
Perfect. Thank you so much. Hey.
All right, Lori. Take care. You bet. You have a good one too. All right. See ya.
Cheers. Cheers, Joe.
All right.